let's look at and sort of turn the clock back to the conversation we were having earlier, and that was where the potential markets lie. Now, we've looked at M&As, we've looked at getting into the minds of the transactional lawyers on shore, we looked at marketing the jurisdiction. What about locally, Judge? Are there any opportunities this side of the Atlantic that we should be looking at?
Well, that's a good question in the sense that, you know, one of the things that crossed my mind is as relationships between the U.S. and Cuba develop, how are those disputes going to be settled? And there's no answer to that, and maybe sometime before there's those kind of business relationships. But for example, there's a country in the region, they're certainly not going to be settled in the U.S. or in Cuba. So who's going to get that business? Now, if there's a center here that can handle them, there may be advantages. There's also the language disadvantage that this is an English-speaking jurisdiction primarily, not a Spanish-speaking jurisdiction. So looking at those kind of things, I'm not saying that's necessarily should be on the radar screen, but it's to really take the things that we've got, and that's what Doug was saying to a large degree. Look at what our various advantages are, and figure out where there's places where that fits. And you know, that's one of the great advantages of this conference is the people in the room are going to have ideas, and I assume we're going to be sending emails to Don on a constant basis with, you know, here's a niche that we could be tapping into, and I don't know what. Whether they're apart from sort of the infrastructure projects, which one could take a Qatar type of approach to it and say require that they have arbitration clauses in arbitration here, and that's, if you want the contract, that's part of what you get. But apart from that kind of thing, I'm not sure right here what there are, again, within the region.
Well, I think Cuba's a great example, and Doug touched on it earlier, that if we can offer neutrality in an emerging jurisdiction like Cuba and the vast economic potential that it has, if the BVI could position itself to become an arbitration centre for that kind of commerce, then we'd be very well set indeed. Doug, any other opportunities around the local area? Miami, for example, is struggling without a formal arbitration centre, I understand. Can we start poaching work from the States itself, do you think?
Well, one hesitates to say it, so close to the United States.
And they may be listening.
But it's not a safe seat. The Federal Arbitration Act, which for political reasons is unlikely to ever be reformed in the Congress, is a piece of 1930s arbitration antiquity. And some of the centres, such as Miami and New York, are passing state legislation to try and solve the problem. But you can't have that with international arbitration without consent. So I say to the Canadians, who in their right mind, making a decent legal choice, would choose a seat in New York as opposed to Toronto? It's not legally safe. And when you look at the way the FAA has been interpreted by different circuits, so far as, say, manifest disregard is concerned, you don't know where you're going to finish up. So I would not hesitate as an Australian, although others may be more hesitant, to say we are a close, safe seat. Miami is pushing very hard for the Latin American arbitration. But if you want to run an arbitration in Miami, you don't have a centre. And the hotels aren't obviously easily available. I mean, one of the things we did in Sydney, which you're going to have to do here, and to a certain extent was done for this conference, is offer what we call concierge arbitration. That is, parties want to come here for an arbitration, they have a single point of contact. I'm looking at Dawn, who isn't looking at me. A single point of contact. We want to come to the BVI for an arbitration. Where are we going to stay? Where's the hearing going to be? Where do we get our transcribers from? where are we going to get our document sorters from, what sort of video facilities are we going to have, and how are we going to do it. And if you want to come to Sydney, you come to a single point of contact, and that will be organised for you. Hong Kong has picked that up, having got the idea from Sydney. I'm trying to be careful. I have the deputy chairman of the Hong Kong International Arbitration Centre close to me. And they're doing it quite well now. If you want to have an arbitration, if you've got an arbitration in Hong Kong, you get a note from the HKIAC a couple of weeks beforehand saying, you're coming to have an arbitration at our centre. Can we help you with accommodation, organising, whatever, and doing it? And by the way, they say, we have special rates at the Mandarin Oriental, which for me is very persuasive because it's both close and the best hotel in the world. And we'll give you these really heavily discounted rates. So that sort of concierge approach is something you've no doubt thought of and which you will implement. And if you've got trouble getting in, we have a private jet charter company with special rates for coming to the BVI. Am I joking? No. Well, yeah, you see, I mean, that's one way of solving the transportation problem.
Perfect. Thank you, Doug. That was excellent. Thank you. I was going to move on to Lord Goldsmith now, but I've just been told that I've got to move into questions. So if the first question, if anyone does have them, could be directed at Lord Goldsmith, very, very appreciated.
Or I can ask them a question.
It's an excellent idea.
So you've talked about the region, okay, the regional business. Doug has talked about Miami, which for various reasons is not an ideal substitute. Where else is there in the Caribbean that you could do this? The only place that begins to occur to me is Cayman, but there may be other places as well. What do the audience think? If there's going to be, whether it's for regional business or just in global business, but arbitrating in the Caribbean, where else but BVI?
Well, what other competitors do we have at the moment? I think Trinidad has a centre. Adeniki.
Barbados would be great. The Bahamas is a something. They've got the legislative frameworks in order to develop here. So they can be alternative choices in terms of continuing for this process. And in fact, they're trying to do just that.
Thank you, Calvin. What stage have they got to, just so we know where we are on the...
say that. They've put out studies, they've conducted studies, they have the government support, they're now looking for financing and those sorts of things. So they're pretty much along.
But behind us.
Huh?
But behind us. Adeniki.
I'm actually so however, I have a question more directly this side, thank you, of the panel. But if you would like, I could wait if you would like more questions on...
No, you go ahead. Everyone's waiting for their lunch, so...
Okay. If the question is Justice Leon, please feel free to comment on. I'm looking forward to comments on that from Constance as well. Can you hear me? I'm instructed to stand. Okay. I'm following on from what you said, Jerry, regarding introducing arbitration clauses in articles of associations for companies. And I'm going to start with a few statements and then I'll leave it open for you to comment on. The first thing is, with respect to entering into a contractual agreement, and I think an arbitration agreement is exactly that, an agreement, you would need the parties for their minds to have met. There has to be a meeting of the minds. And that's the first statement. The second thing is, I find that with respect to BVI companies, when you look at the memorandum and articles of association, they would tend to reflect what the BVI Business Companies Act would deal with, because that act governs companies. The M&A are essentially clauses and regulations or the bylaws of a company, so they would naturally reflect or refer to or defer to the legislation and deal with issues, for example, that the legislation may also defer to them. Many sections in the Act state, subject to a company's M&A, XYZ, XYZ, XYZ. That's the second statement. What I'm leading up to say is, many times clients who purchase companies or even shareholders themselves would expect the articles to deal with matters that are left to be governed by those articles as mandated by the BVI Business Companies Act. I don't think they would necessarily expect an arbitration clause on an arbitration agreement to pop up in there. And if you look at what we've been discussing throughout, we would like to ensure that arbitration clauses or agreements are properly drafted. We would like the parties to these agreements to have their minds meeting on these issues and agreeing upon these issues. And I think in most cases, you'll have a client coming to a trust company and sometimes just wanting to purchase a company, and they'll get a standard M&A. Many times the shareholders have not read them, which we know it's incumbent on them to do, but I'm just listing what we know actually happens, is that they get the companies really quickly. They may wish to use the company for inheritance purposes or tax structures, but they may not have read that and realized that there's an arbitration clause in them.
So is your point the surprise of the clause? Is that really?
Which may occur with a lot of clients. A lot of shareholders may at the end of the day realize that this is the situation and that the courts will uphold the arbitration clause provided it is a valid arbitration clause. So I just wanted to know what your comments are, considering the background, considering that the parties' minds may not have met upon this issue. They may not have addressed any terms whatsoever.
But that's probably true of a lot of what's in the document. As you said, they haven't read it. So, how much of the company law do they actually direct their mind to, and particularly when it comes to disputes? But it's there, the opportunity is there for them to do it. Whether they avail themselves of it or not is a different question. But it's like a lot of remedies that are built into the Companies Act and other statutes. They're there. People may be surprised to find they're there, or be surprised to find consequences. But the remedy is that they should be, they or their lawyers should be paying attention to the contracts.
That's true.
I'd just like to jump in there just very quickly. Sorry, Andy. Obviously, one of the prime selling points of the BVI is that you have a very well-established legal system with ultimate redress up to the Privy Council. Is there a danger that we are selling arbitration within our M&As and losing that integral part of what's made the BVI so successful?
Well, people choosing arbitration are choosing to have their disputes resolved without the expansive appeals that are available from the court system. That's one of the reasons why people often choose arbitration. So you're still maintaining the court system in the Eastern Caribbean and to the Privy Council when it comes to issues arising from arbitration that properly can go up. But you're right, it's a choice of a dispute resolution process that is supposed to be final and binding and has very limited rights of court review afterwards.
Yeah, Antonika, also.
You wanted to ask something
When
else?
Justice Leon mentioned that they've chosen, many times if it's in the Articles of Association, although we know what should have happened, they may not have been aware, may not have chosen based on the facts of the particular situation.
Yeah.
With respect to a shareholders agreement, I would expect that there would be discussion between the lawyers who are drafting the documents and they'll be getting input and advising their clients. That may not have occurred at the point of incorporation.
But that may very well be so. I think you will also find that there may be a similarly astonishing extent to which shareholders may not have read every clause in the shareholder agreement as well. And it comes back to a point which I believe either Lord Goldsmith or Doug made early on, that a lot of this is going to be lawyer driven. Clients are going to a large extent rely on their lawyers in terms of things like arbitration, where should be the seat of arbitration, choice of law clauses, etc., etc. Not to say that every client is going to be completely removed from those issues, particularly where you're dealing with major commercial transactions. And this ties into the whole issue of, well, what is the role for practitioners here in the BVI in assisting in seeing this whole initiative come to fruition, and the BVI gets its a fair share of the international arbitration business? And how does this tie in with their offices in other major and key jurisdictions, even jurisdictions that are leading centers for arbitration in the world? So what do we need to do in the BVI that is going to make the BVI to a significant extent to be the choice in terms of the seat of arbitration and choice of law for arbitration purposes? And in the end, you know, there is going to be a question of confidence. There's going to be a question of confidence, and that incorporates so many different factors that must come together in order for there to be confidence. I mean, it's the same issue in relation to the BVI as a domicile and corporation jurisdiction. What is the level of confidence? And most importantly, when we look at the commercial court, it also comes down to a question of confidence, because in the end, you know, how is it that we were so successful in having the commercial court in the BVI, which, even though it is a court of the Eastern Caribbean Supreme Court, internationally it is really thought of as the BVI commercial court, even though it is just seated in the BVI, but it's seated here for good reason. It's not just that we are, you know, such a beautiful location in terms of, you know, topography and otherwise, which we are, but also to the question of the confidence in the judiciary, the confidence in what the court can deliver in terms of disputes and getting decisions and so on in relation to disputes of significance, and how does the role of that court tie in with the whole question of the resolution of disputes through litigation internationally, because oftentimes our courts are indeed complementing or providing a role that is ancillary to main proceedings that are going on elsewhere. This is also part of what we must use to sell the BVI as an international arbitration center, and to build that confidence, and ultimately to get to the point where you do attract some business, and most importantly, that business is handled in the way in which it ought to be handled, and it may come back to providing sort of boutique services and all those sort of things as well. But how competently and how thoroughly that business is handled from the point of view of the center, etc., in the BVI, in order to begin to build that confidence internationally. It's not going to be a situation where, you know, we set up the center, yes, we have the legislation, we go out to market, and all of a sudden, you know, we have all this business coming to the BVI. It's an extremely competitive area worldwide, and we have to find those areas of business where, call them niche areas or whatever, where the BVI can be able to legitimately provide some sort of advantage, or to at least be equally as attractive as some of its major competitors internationally, be they or even in the region itself.
Thank you very much, Jerry. And the sign's been held out, so it's lunchtime, and I don't want to make even an average lawyer even more unpopular. But Lord Goldsmith, one last point.
Right.
What have we got to get right?
You've got the law right. You've got the treaty obligations right. You've got the commitment right. You've got to do the work now to make that achieved.
Wonderful. Well, thank you very much, and thank you very much to our very esteemed panel. Thank you for everyone attending. Do enjoy your lunch, and we'll see you after lunch for some more scintillating arbitration sessions. Thank you very much.